while we're waiting for some more people to come in, we're almost the 400 people mark. What I thought I would do is, before I introduce you to the real experts, just introduce you to two other experts that you might hear from today. The first is this is Morris, my dog. He's a golden retriever, and apparently golden retrievers have the loudest bark of any dog. And Morris definitely lives up to that reputation. When he barks during webinars and meetings, I'm convinced he's agreeing with me. Some people think he's disagreeing with me, but on the whole, he's reasonably agreeable. And then the other expert in our house is my daughter, Emma, who is doing online school, which involves clarinets and pianos. So if you hear some nice music in the background, then that will be her. All right, we're almost 450 mark, which is great. And so today we're going to be talking about essentially, what is your plan for data protection? Because we've only got 5 months to the POPIA deadline. Those are the outcomes from the webinar, which you know about, which is why you would have signed up. And I think let me now stop sharing and go across to the real experts who are joining us today. So my name is John Giles. I'm the managing attorney at Michalsons, and essentially I help organizations to comply with complex data protection laws. And then we've got Mark Hank, and Mark and I have actually been working together in some form or another for about 21 years, which is quite remarkable. Mark doesn't really need any introduction. He's got a wealth of experience in IT and data protection law in a South African context. And Mark, it's fantastic to have you here today.
Thanks, John. Hello, everybody.
And then we've got Michelle Davin, who is one of our attorneys. She's an experienced attorney who, focusing on data protection and has a particular passion for helping to protect children by protecting their personal information. And Michelle's going to be performing a role of helping in the chat box, helping to identify themes in the questions and trying to facilitate us answering as many questions of yours as possible. So welcome, Michelle.
Welcome, everyone.
Great. So we are a big group. We're almost 500 now. So it's going to be a fantastic session. We can do some really nice polls, which I'm looking forward to. We can also have lots of questions, and we want to try and answer your questions. So please ask them in the Q&A functionality. You can also ask them in the chat. Actually, asking them in the chat's probably better. Michelle will try and answer the ones that she can and maybe send links to different things that you're asking about. I have had some questions in advance of today's session, and I will try and reach some of those as well. We want to try and keep today to an hour, and so we'll try and answer as many questions, but we might not get to all of them. Then the other key thing is we really want to keep to today's topic because there's so much to talk about data protection, but today we specifically want to talk about the fact that we've got 155 days left. I counted them, and it's 155 days to the deadline. And so we're really talking about what's your plan? And that's what we will be kicking off with today. So before we start, I'd really like to get to know a little bit more about you and who's here. So I'd like to run a few polls quickly, and if you wouldn't mind answering these really fast so that we can get through them quickly. The first is, what's your role in the organization as an individual? Be interesting to see just the spread of who's actually here in terms of role. So if you wouldn't mind ticking one of those, maybe tick the one that's most appropriate. I think it's multiple choice, so you can tick multiple if you perform multiple roles. Great, I can see you're quick off the mark. That's fantastic. We've got 60% voted, 70% voted. We're looking good. And we've also just hit the 500 mark of attendees, which is lovely. Okay, that's about 85% of you. So let's end that poll and share those results. And it's a really even spread, which is interesting. Probably compliance winning, but we've then got an even spread in all different categories, which is great. All right, and then the other poll I wanted to quickly ask was, what size is your organization? And this is important because we're going to go through today the plan for most organizations, for most sectors or industries, and also most size organizations. The plan really stays quite similar. But it obviously is going to adjust. And if you're a small organization, you're going to skip through these steps much quicker. If you're a larger organization, it's going to take you longer to work through it. And I'll try and contextualize that in the context of the plan. But really, what's interesting is that we've engaged and assisted multiple sectors, multiple sizes, and really we think the steps of your plan are very similar. And we've got almost everyone voted there, so let's share the results there. Mainly large organizations, but medium and small close behind. So we really do have a spread right across the spectrum. All right, let's then kick across to our presentation, but I just wanted to check, Mark, any thoughts or comments at this point?
I think that the important thing is there is a lot that needs to be done, and a lot of organizations will be in different, they've progressed, some of them will have progressed quite far, some of them will still have quite a lot to do. But as John quite often says, don't panic about it. There are mechanisms that can help you deal with this. We don't have a lot of time. I think that we have to stress that that at this stage, those of you that have not done anything, there's a lot to do, and there's a lot to understand. But quite often, once you understand what is necessary, what needs to be done falls into place reasonably quickly. And in many instances, you'll find that you do things to protect personal information, like your information security. You're already doing some of the things. The important thing is don't go and duplicate that, rather actually bring it into your data protection program and how you're going to deal with data protection. Thanks, John.
Great, thanks, Mark. And I'm going to share my screen now, and that's exactly what I wanted to start with, was to say, don't panic and keep calm. There's 155 days, but there is time to do this. And I also think that nobody's going to go to jail for this. Yes, some organizations will get fined over time. I don't know how quickly that will happen, but that will happen. And some organizations might face damages claims, and many might suffer reputational damage. But we do have time, and we can do this. We've got this, and you're probably 80% of the way there already. All right, so what I wanted to start off with, in terms of making a plan, you need to really start with your timeline. And so I'm going to come here to this slide, which is our data protection timeline. We've updated it, and I wanted to talk you through some of the key things that are happening at the moment. So the black line is the passing of time, and below that line are the different deadlines and grace periods for different data protection laws. And then above the line is reflecting the effort that you're going to be putting in. And those are the things that are in your control. That's the process and your plan, essentially. But let's talk about below the line first and look at what's been going on. The first thing to mention is that the GDPR has fallen off this timeline because the deadline for the GDPR was in May 2018. And if you needed to comply with that, that was 2 years ago. We can also learn a lot from what happened with the GDPR and happened particularly around the deadline there. Essentially, there was a mad rush in the lead up the last 2 months to the deadline. But then authorities and regulators in Europe were quite lax after the deadline. And I think this is a key point from today, is that yes, 1 July 2021 is the deadline, but the world's not going to end on that day. It will continue the next day. And the information regulator, whilst they haven't confirmed this, I think are not going to come down hard the day after the deadline. It will be a process of adjusting to it. So the American law has commenced on the 1st of July last year. There was a 6-month grace period. The Brazilian law commenced last year, and the deadline for that is 1 August. The Californians have enacted a new law which will replace the CCPA, and that has a significant grace period. It's only 2023 until it replaces. And we're waiting in Europe for the e-privacy regulation. And those are some of the key developments globally that might have an impact on you. But really, this is the timeline that most people are interested in. It's really The POPIA commencement date was on 1 July with a 12-month grace period, which means we have a deadline of 1 July 2021. Now, that gives us 5 months, and we're more than halfway through the grace period. So we've been thinking about this 5 months. There really isn't time to lose. You've got to get cracking if you haven't already, and I'll ask you some questions around that in terms of a poll. But I think an interesting thought here is that we've been engaging with the information regulator, and they are aiming to have various things in place that they need to do by 1 April 2021, which coincides with the government fiscal year. And so there's an article on our website, which is this one here. I'll quickly just show you, and you can access it if you would like to look at it. It's this one here, the Readiness Plan for Implementation of POPIA. And it explains what the regulator's aiming to achieve at different points in time. And so there are many things that you can't do now because you need to wait for the regulator to enable it, like registering your information officer is a classic example, or getting prior authorization is another example. And so in both those cases, don't stress too much about the information regulator's timeline. You'll be able to do that at a point, and we'll notify you when it's possible to do certain things. At the moment, it's important, I think, to focus on what's within your control and to try and get those things done. So back to the timeline, we're expecting the 2 months prior to 1 July to be extremely busy. We're going to be run off our feet, so will the regulator, so will everyone. So don't leave it to the last minute, because if you're looking for support at that point in time, it's going to be really tricky. All right, that's the timeline. We don't believe that the timeline, the grace period will be extended. We think that 1 July will be the date, given the length of time that this has taken to implement. But what I thought we could quickly do, let's run a poll, and I'd be interested in your thoughts of whether you think the grace period might be extended. So let's, be interesting to see. We've got 550 people now are here. And if you wouldn't mind ticking one of those boxes. Just while we're waiting for those results, Mark, any thoughts from your side?
Just a couple of things. The first thing is that we are awaiting guidelines from the information regulator on codes of conduct, on prior authorization. And I think that there are also regulations that have to come from the Department of Justice relating to the handover eventually of the regulation, or the administration rather, of PIA by the information regulator. So there is quite a lot that we need to look out for over the next while. And one of the things is, just remember, with prior authorization, at this stage, it's not clear how the regulator is going to deal with prior authorization. And if you don't have a code of conduct and you are processing certain categories of information, you will require prior authorization. So I think that it is important that you look out for those guidelines and that you deal with them as quickly as possible. One of the ways of making sure that you are up to date is that immediately we receive news on that, it will be on the Michalsons website. So that will allow you to be able to actually take a look at that fairly quickly and be able to address it, and where necessary, get assistance on that. Insofar as codes of conduct are concerned, typically codes of conduct are being dealt with at an industry level, and the industry representatives or industry bodies, I think that they also need to take careful note of what might happen with the codes of conduct. I understand, and I say this is unofficial, it's not anything that has been provided to me, but I understand that the codes of conduct, if we look at the draft that was published by the information regulator a little while ago, that's not going to change that much. So when we look at codes of conduct, possibly that's something that you can bear in mind. You can look at that. There might be changes, but I understand they're not going to be that material. Thanks, John.
Great, thanks, Mark. And just a quick question from Anonymous asking, Are there still any POPIA regulations outstanding? And if so, when are they expected to be promulgated? So it's relating to what Mark said. We have the regulations. We're not waiting for more regulations, but there are various guidelines that we are waiting for. And then there's some other questions which we'll tackle just now, I think. Michelle, anything from your side?
Not at the moment, John, just a whole lot of interesting questions that are coming through, but I think maybe we can answer them a little bit later.
Okay, great. And Susan, yes, I know that there are lots of acronyms, and I'm sorry that I'm throwing them out there. I think the key ones are POPIA, stands for Protection of Personal Information Act. The other one is the GDPR, which is the General Data Protection Regulation. And there is actually a data protection glossary on our website, which would help you with the different terms. All right, thanks very much, Michelle. All right, so that's essentially the timeline in terms of what's happening down below the line. Above the line, we've tried to show you where you really should be in terms of your plan or your progress in working through different steps. And for us, the steps are learn, plan, protect, and sustain. And those 4 steps are what you should be working through. The plan step being very important. And I'm going to focus a bit on that plan step to really show you what the steps are of what we believe your plan should be. One other key point, and so this will change based on whether you're large, medium, or small, also what the impact is on your organization. But the one thought here is that the light green line is the information officer, which you'll see is stable. The information officer has been a role in your organization for years already, and that role will continue. It's a permanent role. And there is a lot of work to be done in the run-up to this deadline, and the information officer can't do it all. They're going to need to bring in other people within the organization and third parties as well in order to assist. But let's leave that there for the moment. I want to then zoom out to the whole of our presentation, which really follows these steps of learn, plan, protect, and sustain. But I want, in terms of the introduction, just to mention a couple of points to you that are really important from a planning perspective. The first is that you need to know what you're trying to comply with. And it sounds crazy, but I promise you it's probably not just POPIA, so the South African law. There probably are a few data protection laws that you need to comply with. And then I think what's crucial is also to identify what standards you're going to comply with. What codes do you have to or want to comply with? And are there any additional rules? And I think particularly here from a standards perspective, you want to be looking at things like 27001 and ISO 27701. But there are multiple standards. And again, there's lots of information about that. But the law almost just creates the principles that apply. To put the meat on the skeleton, you almost need to be identifying which standards you want to comply with and possibly which frameworks you want to follow as well. And so it's very important at the beginning to think about that and make decisions around what you're actually trying to comply with. Mark, I don't know if you've got any thoughts on that.
Yes, John's mentioned the ISO standards, and one of the things that I do think is worthwhile for organizations, particularly larger organizations that already have a basis on the information security that is on the ISO standards, is that the publication of ISO 27701, which is an extension of 27001 and then 27002. 27001 provides for how you actually put into place an information security management system, and 27002 sets out some of the control measures that you can use in ensuring that those are done. What 27701 does is that it gives an extension. So if you've already got that in place, you can start building on what you've got and just look at the control measures that are in addition to those to actually deal with the protection of personal information. And I think that we are going to see a shift to, this is principle-based legislation. The legislation doesn't change that much, the principles don't change that much from country to country, but how you actually address them, what protections you put into place, are decisions that you're going to have to make. And if you are already on the ISO 27001 route, you might as well look very closely at 27701. I did notice that Carolyn Mouton, I think it was, indicated or asked how we leverage this. And my suggestion to you is, yes, if you are in a position to leverage what you already have, 27701 gives you a very handy tool to be able to do that. Thanks, John.
Perfect. Thanks very much, Mark. Yeah, and I just want to stress the point that many people get halfway through their plan or through their program, and then they start wondering what they're actually trying to comply with. And so to deal with this issue right at the front makes a lot of sense. Then the next point I wanted to make is that it really is different for different organizations. And so it's very important for you to understand what's the impact on your specific organization, how ready are you, but then to identify your compliance strategy and your program strategy, which is really about saying, what's our plan? And that's a very important thing to do. And it's a combination of those four aspects that will help you to formulate your strategy and your plan. All right, let's move on from there. And I want to go now to the plan step. And so if you're thinking, what's our plan for, you might be a school, you might be a community scheme, you might be a large organization or a bank or multiple people, but what are the steps we should be taking as part of planning? And we've really thought about this a lot. We've done this exercise with many companies, and we really believe that these are the steps to take in this order. And I'll explain a little bit why that's the case. And it obviously will be different depending on how large you are. But for us, your plan needs to start with getting governance right. You need to brief your executives or your governing body so that they know what the situation is. You then need to determine, do we need a data protection officer? And then vitally is to identify an information officer or who your default one is, and then appoint somebody to the role if necessary by delegating and designating that person in writing. That's an absolutely crucial step as part of your plan. And then you want to set up a governance model, which looks something like this. This is obviously for a larger organization, but it's really important to get this governance model in place. And essentially what it's about is knowing who does what, so that when you're identifying actions, you're assigning them to the correct person, and you've got the right people doing the right things. All right, the next step is to identify what software or privacy management systems or platforms you should be using. Again, now this is something that organizations often come to too late in the process. It's really important to do this early on in your plan. What tools are you going to use? And there is some amazing software that's very useful in doing all sorts of aspects of this project. And so your plan needs to entail looking at different options, getting demos of those options, considering what suits you best, and then implementing those options. We've done a lot of work in this regard. I'm not going to go into more detail unless there are questions around it. We can always field them at the end. The next thing would be to interpret the law for your organization and answer some questions of how do you interpret the law for your particular circumstances. There's a lot to that as well, but I'll leave that there. The next one is it's important to map your activities and create a record of your processing activities, or what's called a ROPA, the acronym for Record of Processing Activities. And this is where you can do it manually. You can just focus on one or two of your main activities, or you can do it in a very detailed way. But as soon as you're doing that, you really do need software. So the reason that's a critical thing to do before you do a gap analysis is that you can't analyze the extent to which you are applying the data protection principles to your activities unless you know what your activities are. And it's very hard to map activities unless you've identified what tools you're going to be using to map your activities and do a gap analysis. And that's why this order is very important. So talking then about a gap analysis, the key thing with a gap analysis is that you're comparing your organization to a regulatory requirement to identify gaps, which then enables you to identify what action needs to be taken to remedy those gaps. But there are many different kinds of gap analysis. There's one where you're looking just at the obligations in POPIA. There's one where you're applying the principles to your activities. The regulatory requirement might be 27701. It really depends on many factors. And I think a key point here in terms of a plan for people is don't think you should start with a gap analysis. And also, it might not be appropriate to do a gap analysis for your organization. You know, I often say to people, if you know your 10 big gaps, why not plug those gaps, take action, fill those gaps first, then do a gap analysis, because the gap analysis is then going to be a much easier exercise. And in other words, don't spend all your time focusing on what the problems are rather than finding solutions for those problems. So a gap analysis definitely has a function to perform, and there's lots to discuss there. But in terms of your plan, don't necessarily go for a gap analysis as the starting point. And also don't necessarily go for a comprehensive gap analysis. You can do a smaller gap analysis in particular areas that would help you make significant progress quickly. All right, so then coming out of a gap analysis is going to be, you're going to identify what actions need to be taken, and you then need to prioritize those actions using a risk cost analysis, or there are many ways of prioritizing. You need to assign those to different people, and once you've assigned them, you really need to have a mechanism for managing those actions. Here's just a simple table where you've got the action, the status of it, who's going to do it, how long it's going to take, when the deadline is, and notes relating to it. But as part of your project plan, it's also to identify what project management tool you're going to be using, or program management tool, how you're actually going to get that done. So then based on that, you can get a roadmap, and you can start getting an idea of when you're planning to do different things. This just illustrates the agile versus a waterfall methodology, and looking at process versus implementation actions. But without going into too much detail, these are the steps that you really need to follow as your plan in order to then identify what action needs to be taken to protect personal data. People often want quick wins and actions to take first, which are good to do, but I think we're at the stage still in the process now that we've got 5 months. Let's rather go through the complete steps of plan rather than going to quick wins now. But you can do that. There are many quick wins, and you could look at doing that. And then the actions to take first list is really looking at when we get to a month before or 2 weeks before, what do you need to implement at that point in order to follow a risk-based approach, but really get some key things in place. So that's really for us the steps as part of your plan. That's what you should be, that's how you plan what action to take, and that should be part of your plan. And I would also say that you want to spend more time on actually protecting personal data and implementing rather than planning. So if you've got 5 months and you're starting now, you want to spend a month planning and then probably 3 or 4 months protecting, with a month, well, sustaining is really something that then happens on an ongoing basis after that. So you really could divide plan and protect into the next 5 months and really work on plan for a month and protect for 4 months would be a good split on that. So on that note, let's go to a poll and let's get some feedback from you. So let's ask this question first. So the question is, do you have a plan or program for the next 5 months? And let's just get a feel of where you're at.
John?
Yes.
While we're busy, I just see there are a lot of questions coming through about, whether the slides will be made available and the recordings as well.
Yes, sure. So I'm pretty sure we'll be recording it, and I think what will happen is there'll be an email sent to all attendees afterwards, which will give you the recording and all the ability to download it. So I'll follow up on that and see that that it happens from a technical perspective. If you don't get it, then you can contact support@michalsons.com, and we should be able to get it to you that way.
Thank you.
Great, thanks, Michelle. So if we end that poll and let's share the results. So most people are saying, yes, they've got a plan, but it needs work. And many people saying, no, and I need one. So that at a high level, what we've just shown you now would be the plan. That's what we would suggest that you do over the next while. I think what would also be interesting is based on the steps I've just shown you, maybe if you could answer, what step are you currently on? They might have different names and yeah, generally speaking, they call different things, but really the steps are the same. They achieve the same things. Yeah, this really is wonderful to have a large audience and to be able to get a quick view across the audience on different issues.
While we're waiting, a couple of the questions that have been asked that we can possibly answer in the meantime is a question relating to PCI DSS, which is the payment card industry data security standard. And of course, that you can use. You'll find that that if you have implemented a lot of those things from an information security perspective, that is definitely going to assist you, because those are principles that are fairly common through information security standards. But I voice a word of warning, that doesn't take, information security is not the be all and end all. You do need to look at some of the other compliance issues in POPIA that you will have to apply. And the fact of the matter is that, if you are considering it from a particular perspective, like payment card, it might be that you don't look at some of the other perspectives within your organization. So for instance, one of the things that has come up, and I noticed that there are members, obviously from the health industry, because there are quite a few questions around special personal information and what it is, etc. Now, that is an area where I think there's quite a lot of work to be done, both from the point of view of the medical profession and giving guidance in that regard. We do have some information on the Michalsons website, but you could also find quite a lot of information on other regulators' websites that are certainly considered and as persuasive by the regulator. There's a lot of information out there on medical information that you could probably take a look at. Then just simply from the point of view of software, one of the questions that seems to have come up on a couple of occasions is the classification of information, and is software available to be able to do that? Yes, very definitely. There's quite a lot of different elements of the software, but you will need to look at how that software can be used within your organization and what suits you best. What John has already mentioned relating to, in your planning, determining what software is going to suit your needs best. Thanks, John.
Thanks, Mark. That's great. Yeah, and so while you were talking, the results came in, and most people are in the plan or protect stage, which is fantastic, and what I'd anticipate. Yeah, so that was an interesting poll to do. So maybe, Mark, just to also add one more thing to what you were mentioning, I think that Yashwin asked around in the context of medical aids and schemes. And one of the good questions was saying, are we expecting a code of conduct for health-related information? And in that regard, the regulator, in terms of Section 32, is actually permitted to produce specific guidelines, if you like, or rules or a code on health-related information. And quite some time ago, the regulator did mention that they were working on this. And so I think it is possible that that might come out. I haven't seen anything about that for a while. I don't know, Mark, if you've heard anything about that.
No, John, I haven't. I know that some years, literally years ago, I did introduce some people from the health industry in regulatory positions to the regulator. And but I'm not sure what has transpired from that and where they might be with those codes.
Okay, great. Yeah, Michelle, should we go to some more questions? Are there any other themes of questions that are coming through?
There was a specific question also with regards to data, health data, and also with regards to children, and I think I can answer that. So it's with children, they fall in another category called special personal information. So it's obviously always important just to make sure that you're using the information for the purpose that it was intended to, that it must be, the information, the data must be kept, it must be updated. But with children, obviously getting prior consent from their guardians or their parents, and if they don't have, then the High Court of South Africa is regarded as the upper guardian of children. And the same with medical information or health data, that's also regarded as special personal information. So that is something that, the risk is higher on your organization, and make sure that you put specific safeguards and standards in place and that you adhere to the standards. Yeah.
Yeah, great, Michelle. And just to add to that, Yashwin also asked in prep for today's session about prior authorization, particularly for health-related information. And one of the things that I think is relevant for everyone is that it's very important to make a distinction between special personal information and the particular activities that require prior authorization from the regulator. So the way it works is that personal information, everyone can process. You don't need authorization. You don't need to notify the regulator. You can go ahead, provided you're complying with the conditions or the principles. When it comes to special personal data, you need to check that the law authorizes you to process that. And so the law has detailed sections relating to when POPIA itself authorizes you to process that. You don't need to notify the regulator in that case. You just need to check that the law authorizes you, and you might be challenged at a point in time as to why you believed you were authorized by law to do it. And then there's some specific instances where you have to get prior authorization from the regulator, and you can't process it until you get that prior authorization. And maybe if I quickly share my screen, I'll just show you the section that relates to that. It's this section over here, which is, sorry, not that one. So it's here, prior authorization, and this is what is subject to prior authorization. I'll make it a bigger view. So it's things like if you are processing unique identifiers for a purpose other than the original purpose, or criminal behavior, or for credit reporting, in those cases, you need prior authorization. But for health and for children, you just need to be authorized by law, and that doesn't involve approaching the regulator. And I think that's a very important distinction to make a difference between.
John, there's also a trend with regards to deputy information officers. So there's a question from Christopher saying, for a financial services provider with under 500 employees, what is the right number of deputy information officers, noting the minimum is 1?
Yes, and Marco, would you want to answer that?
Okay. First of all, with information officers, really, I mean, you have to have an information officer. Well, if there's an information officer by default, that's the CEO of the organization. And there are a number of questions around information officers that I've looked at while John has been presenting. So if I could deal with a few of them. The first thing is, there isn't a prescribed number of information officers or deputy information officers that you need to put into place. So whether it's 500, etc., it really depends on the type of processing that you're doing, the nature of the information that you might be processing, and the tools that you have. So very often, if you're going to do this manually, you're going to need more people. It's as simple as that. If you are going to be able to leverage software to do quite a lot of this, it will allow less people to actually have a dashboard, look at what is happening, and be able to assist in dealing with the information and how it is being processed. So from that perspective, there isn't a specific number. You really need to assess what your organization needs, and ensure that those roles can be properly allocated, that those people that you give that responsibility to have the necessary resources. Now, what are the necessary resources? First of all, they have to have the knowledge. So, one of the things is that you can actually allow them to self-train. There are some, there's information. The Michalsons website has quite a lot of information on the responsibilities, etc., of information officers. The Act sets out the responsibilities. There are regulations which set out the responsibilities of information officers, but they are at a high level. You need to take a look at that and say, what do we need in our organization? The other thing is that when you look at your information officers, yes, you should be qualifying them to some degree. They need to know what they're doing. If you don't give them the necessary background, and if you don't give them the necessary authority. Now, remember, it's all very easy when the CEO says something for that to be done. But if you appoint somebody and they really regard it as an administrator, not a leader, because this does need leadership, it needs people to look at your information and how you process information, and make sure that there's a culture change very often in an organization. So that person will need that. There was also a question around the deadline date of the 31st of March. Well, at this stage, we don't have any indication from the regulator that the guidelines around information officers, those have been dealt with, but how these information officers should be appointed, we don't know whether this is going to be online. We don't know, we've been told that it will be online, but we don't have the background to be able to say how this should be done. So again, I think it's something that the regulator should be providing us with that information as soon as they can, and we will pass that on at the earliest convenience when we know more about it as well. John, I'm not too sure that whether I've missed anything, and possibly you have some additional information.
No, I think that's great, Mark. What you said, I agree with what you've said, and nothing really to add from that perspective.
John, just one or two last questions. There's a trend also with regards to a practical way of complying with the Section 69 requirements regarding opt-in. And then there was another question just regarding account numbers and whether they also are regarded as personal information.
Great, yeah, so let's tackle those. I think Section 69 it's the section, for those of you who don't know, that deals with direct electronic marketing, so email marketing and SMS marketing. And it's quite contentious, and there are lots of issues around it. I've literally spent days in meetings talking about the different components and the nuances. And I think it's beyond the scope of today's workshop to go into that in detail. One thought there is that the Direct Marketing Association of South Africa have developed a code of conduct, which hasn't been issued by the regulator, but it is on their website. And that goes into a bit of detail about some of the questions that many people ask. There's also information on the Michalsons website about what that consent should look like. And also in our data protection program, we go into a lot of detail about the nuances and how to practically implement various aspects of Section 69. And then in account numbers, account numbers are very much part of personal information. But what's interesting in a South African context is that Parliament's decided that if you fail to protect an account number, it's a criminal offence punishable by 10 years or 10 million rand fine. And that's not the case with other kinds of personal information. And this is where, linking back to PCI DSS, it can be very useful to apply PCI not only to credit card holder information, but to all account numbers, including bank account numbers. And that certainly is a clever thing to do because you're mitigating a significant risk. And then, Michelle, I just had a quick look as well. There are a couple other questions. Adams has asked, how comprehensive does your plan need to be? And so POPIA doesn't say you have to have a specific plan, but and the plan should be what's suitable for your organization. It can be really simple. It doesn't need to be comprehensive. But what you do want to do is start building a record of proof that if the regulator was to approach you in 12 months' time or data subject, you'd be able to say, yes, we thought about this. We followed these steps. And that's essentially what us as Michalsons have tried to do, is to create a data protection program which really lays out all the steps as part of those 4: learn, plan, protect, and sustain, that you should work through and implement to the extent that it's necessary for your organization. So maybe I can quickly show you here, if I share my screen. This here is the table of modules of our data protection program. And our program then is broken down into these steps of an introduction, which then goes through all of these aspects. And I saw that somebody asked, what is POPIA all about? And that's what we deal with in that context. And then under Learn, we then give an overview of the different aspects of data protection that are really important to know. And then in Plan, we go into a lot more detail of what we've covered today around getting governance rights and data protection software, for example. So I see that a few people asked about what sort of data protection software would you recommend? And we go into detail in that module in our program about what the options are and what might be suitable for you. Again, it's not a one size fits all. And we're aware of about 30 different kinds of tools that you could use. Some are South African based, some are global. For example, Microsoft's got some amazing tools. There's OneTrust, there's TrustArc, there's Bizonio. The list goes on and on. There really are many, and they are priced differently. They deal with different components differently. And that's really why in our program, we go into some detail around that software and try to help you match what would be most suitable for your organization from a price perspective and also from a practicality perspective. And some of the tools are available for free. Some of them you're already paying for. And so it's important to consider that and look through that. Yeah, so maybe let's stop sharing there. Yeah, I think somebody else also asked about, is there a checklist that's available? And again, that's essentially our data protection program. We've built in checklists or action item lists at the end of each module, which help you to decide, yes, these are the things I need to work through in that context to be able to check that I've done what was needed and what I should be doing.
John, there are a couple of questions that have come up that I'd just like to address very quickly. There's a question around Section 18 and notifications. Now, the point is that you do have to notify data subjects of the information that you are processing. And, at this stage, we don't have guidance from the regulator relating to historical information. We are somehow trying to understand whether this is only going to apply to information going forward and what happens with historical information. But at this stage, my inquiries in this regard remain unanswered. So we are checking up on that. And again, it's something that as soon as we know, we can provide some indication to you. But it was stated previously that this will apply to historical information as well, that you have to actually notify. And I have pointed out to the regulator that this creates a huge overhead on many organizations that might have personal data of literally millions of people and how they should notify them. Then the other thing is that there is a question that Michelle asked a question about where they are acting as an operator as opposed to a responsible party. And first of all, you must be careful that that is the case, Michelle, that you're certain that you're acting as an operator. Where you're acting as an operator, there are a couple of things that you need to look at. First of all, the responsible party then has the obligation of, if they provide any information to you, of ensuring that there's a written agreement around the information security measures that you put into place, the safeguards that you put into place. The other thing that I think is quite important in that regard is that, and I might be wrong about the number, but it was asked, is there an ISO standard? There is an ISO standard that deals with cloud computing, and I think it's 27018, but I'm not 100% certain, but you'll be able to pick that up fairly easily. And yeah, that's me, John, at this stage.
Great, yeah, Mark, that does ring a bell. I think that number might be right. It does sound good to me. So let's go to a couple of polls then. The next poll is asking, do you think you can meet the deadline of 1 July 2021? Again, just to get a feel for how you're feeling. Are you feeling like it's achievable or not? And I think while you're answering that, I think it's important to make a distinction between obligations and principles. So POPIA obliges you to do some things, which is quite it's an obvious list. It might be to register your information officer with the regulator. It might be to, there are many of them. So, but they clearly defined obligations, and meeting those is reasonably easy. Applying principles or conditions to your activities on an ongoing basis is a lot harder and a lot more vague. And that's why I was really saying, and it does look like, if we show you the results here, that most people are actually saying that, yes, we'll have met our obligations, but not all the principles. And I'm anticipating that to be the case. In other words, you're going to be trying forever to apply those principles to your activities and to get it right. And the important fact as well is that it's not a criminal offense if you fail to apply the principles correctly. So it almost anticipates that you will fail, and you will be trying to be as best as you can, but you're not going to get it perfect every time. And then interesting that many people are going to do the important things by following a risk-based approach. I think that's definitely a good option as well. And for you, you might want to follow the quick wins and the actions to take first and implement those in more detail. And again, we've got a module in our program for each of those that enables you to work through those and to determine what you're going to do following a risk-based approach. All right, and then I've got one more poll that I'd like to launch, which really I was asking, what's the main thing you need now to help you be ready for the deadline? And here you could tick multiple ones, and it'll be interesting to see what your thoughts are in what you need at this point in time. And I think while you're filling that out, we've mentioned this before, but it really is going to take a collective effort to try and, for all of us, to get as close as we can to compliance by the deadline. The information regulator, us, organizations, and many others, we really need to work together to try and get this done by 1 July as best we can, because it's such an important issue in terms of protecting people from harm and stopping cybercrime. Great, so the results are coming in. We've 70% have voted. Right, I'll end it there and let's share the results there. So, so the majority are saying a plan or a program. And that's exactly what we've designed in the form of our data protection program. And there's lots of information about that on our website. You can go on the website, in the top right corner is a page called Join Program. You can find out more about our programs for large, medium, and small organizations. And there's pricings there, and you can register for the program on the website. If you're not sure in terms of what your next steps are, we also offer what's called an organizational impact assessment. It's a complimentary service that we offer, and you can complete a questionnaire, and we'll set up a 30-minute appointment with an attorney. And you'll then be able to discuss your answers with that attorney to try and get an understanding of what's the impact on my organization, what should your strategy be, what are your different options, does it make sense to join our program, or does it make sense to ask Michalsons to do various things for you, or is there another way that you could do it? And we really are, we want to help organizations and find the most appropriate way for them to achieve things. Yeah, then we've got, also interestingly, a lot of people saying we need more guidance from the information regulator. And I agree. I see that they've recently created a Twitter account and a Facebook account, and you can follow both of those accounts. The details are on our website on the page about information about the information regulator, but you should find them pretty quickly. And I'm hoping that that's a sign they're going to start communicating more. And I agree, we need some guidelines on various issues, and hopefully that will be coming through. Then
on the two issues that you've just mentioned, the first thing is, insofar as the program is concerned, John has worked for many, many years on creating that program. And there are a lot of attorneys that have contributed to that. And I take no credit for a lot of the really excellent stuff that there is on that program. But one of the things that I think is quite important for you to look at, for those of you that are looking at a program, just remember that the program as it is priced, and I believe that it is almost ludicrously inexpensive from John's perspective, but the pricing is such that it's a monthly program. You're not locked into it for a huge period of time. And if you look at it, and as we have done, we've looked at a lot of other software. There's a lot of software out there that is, when you compare it with what you can see on the Michalsons program, is extremely expensive. It's something that is very valuable, and you're going to have that software to do certain things. But I do encourage you to look at that program, look at the pricing, and determine whether it's worthwhile, even for a short period, taking a look at the program and determining whether it is of value to you. The second thing is, insofar as interacting with the regulator is concerned, I have been the last couple of weeks specifically, because there was an indication that we would have guidelines for codes of conduct and prior authorization. So I've been engaging with the information regulator. And certainly we are taking up with the regulator issues that our members particularly are raising with us. And I intend to try and set up another meeting, a private meeting, to discuss with the regulator some of the burning issues that we see out there in that regard. So we are not just waiting, we are actually acting on some of your needs. Thanks.
Thanks, Mark. Yeah, and just to pick up on what you said, I often say to people that I think in order to solve data protection, you essentially need three things. You need people, and that's people within your organization and sometimes people outside of your organization. You then need technology. You need to use software. As we've discussed, there are various tools. And then you need know-how. And that's really the Michalsons program is the know-how. It's the plan, it's the framework, it's the program. It's the step-by-step guide to getting to compliant. And so you might well have the Michalsons program and various software tools, and then people who are helping you achieve it. And those three things collectively are what's going to help you get to a point where you've got compliance. Yes.
Yeah, that just ties in because one of the attendees asked about how does an organization that captures information manually as opposed to one that uses tech make sure it complies with POPIA. That was just an interesting question, but that ties in with your answer. And then there are just two other trends. The one is with regards to cross-border data flow, and the other one is for organizations that are predominantly or have for many years, according to the question, complied with GDPR regulations and standards, with regards to POPIA and complying to POPIA, just with regards to the gap and with international look and the bigger picture. Yeah.
All right, great. Well, let's try and tackle those three. I'm aware that we are at 12 o'clock. One of the things before we answer those, what I thought I'd quickly show you that's related to this is we've created this page on our website called POPIA FAQs, Your Questions Answered. We've been getting lots of questions and they're often very similar to each other. And so we've created this page where we're trying to answer as many people's questions as possible. And so these are the FAQs. You just click on the plus sign and then it'll give you the answer. You can filter the answers, the Q&As. So you can, for example, go to information officer and just get the Q&As that relate to an information officer or to a regulator or to prior authorization. And we will be building this out in more detail so that we are able to answer as many questions as possible. And the other thought here is that we also, as part of our data protection program, we hold a weekly live webinar, and that's an opportunity for members to ask questions and we delve into more detail on many of these issues. But Michelle, maybe to quickly tackle the ones you've raised, the one is that POPIA applies to personal data in electronic and physical form, and really everything applies regardless of whether it's in electronic or physical form. So you can use technology to manage how you physically process personal data. Then in terms of cross-border transfers, yeah, there's a module for that in the program, and it's a very tricky, difficult area, particularly at the moment globally because of the Schrems II judgment. And really the whole world's trying to figure this out. Regulators and authorities in Europe are being very quiet. Cross-border transfers between America and Europe is a nightmare. So there's really a lot of action there. The one thing that's also happened is that the European Data Protection Board has released new standard conditions of contract that go into contracts between a responsible party and an operator or controller processor. So that's a large discussion which we would take quite a while. And then the other question around the overlap between POPIA and the GDPR is a good one. And let me share my screen here and quickly take you to a diagram that could help. And so if we here at the presentation and we go into the section about the introduction and we go to the global view, really, if you compare most data protection laws, there's about an 80% overlap. But when it comes to POPIA, it's about a 70% overlap, with 10% being extra in POPIA and 20% extra in GDPR. And so the vast majority is in both. And so if you've got to comply with both laws, you want to focus on that common 70%. What we've done here in our data protection program is we've created what we've called a POPIA lens. So our program focuses on the common 70%, and then the POPIA lens gives you the extra 10% and enables you to look at this topic through that lens. And so with the lenses in our programs, and the program being for large, medium, small, you're able to look at data protection from different perspectives, because as we pointed out, it is different for different organizations, and a one-size-fits-all approach doesn't work. All right, we're at the top of the hour. I think we've run out for most things, but maybe, Michelle, any other questions that stand out?
Yes. So a few questions with regards to people having manual registers, especially now with regards to regulations of COVID and people having to come in and filling in a register with regards to you often have to put in your name, your ID number, and then obviously the temperature metering. Just your thoughts with regards to it being personal information and other people being able to see it. That's the one. And the other one is the obligation on one organization working with third parties to ensure that they are POPIA compliant, just with regards to maybe if you can just touch base on responsibilities and the agreements between parties in that sense.
Yes, great. So on the first one, it's obviously a very topical issue at the moment, and there's lots of information on our website about data protection in the context of coronavirus. And most authorities around the world have put out guidelines, including the information regulators put out some guidelines about processing health-related information during the pandemic. And but it's definitely it's definitely personal information. It's any information that identifies you is personal information, and health-related information that's connected to you would be your personal information. And then I forget what the second one was.
The second one was with regards to using third parties and whether you will be held responsible, and how would you ensure that they also comply and they are POPIA compliant?
Sure. So I think Yashwin asked some of these questions, and they are very important. It's really important to establish who the responsible party is, and they just determine why and how to process. And they really are accountable for the processing of any personal data that they do or someone does on their behalf. And so if things go wrong, it's the responsible party who the regulator is going to come to. It's also data subjects will go after the responsible party, which means it's really important to have a good contract in place between the responsible party and the operator, so that if it was the operator's fault, the responsible party would then have some recourse against that operator. And this is where the standard contractual clauses come into play, and also what's becoming generally known globally as a data processing agreement, and is a very important thing to get right. And again, there's a module for that in the program, which looks at managing processing relationships. And actually tomorrow we're doing the webinar in the program, which looks at the role players and will help you to determine when you're the responsible party and when you're an operator, and how to manage the relationship between them.
Thanks, John. I see there are 3 people that raised their hands. Elizabeth, Tessa, Taylor.
Sorry, Michelle, I can't hear you. I don't know whether you're muted, but I'm battling to hear you. I don't know whether everybody else is.
Can you hear me now?
It's just a bit muted. I can still hear you, but it's very low.
Let's quickly see.
That's better.
Okay. Thanks, Mark. I just said there are 3 people that's been raising their hand, showing for quite a bit. It's Elizabeth, Tessa Taylor, and Eben Jacobs. I don't know how we would like to go about.
Yes.
Oh, I see. I
so
think
Elizabeth,
Eben
I've got an email. Okay, and Elizabeth, I've got your email. I'll respond to your email. I think that might be what you're wanting to ask. And the other 2 people have put their hands down. Yeah, sure. So it's 12:10. We're a little bit over time. Thank you very much for staying as long as you have. And yeah, thank you very much for attending. If you'd like more information about anything we've been discussing, there is a lot on the Michalsons website. You can find out about our program there. And we will be sending you an email with a recording from today. And thank you very much to Mark and Michelle. I really appreciate your inputs.
Welcome. Thank you, everybody, and goodbye.
Thanks, everyone. Have a lovely day.
Yes, great. Have a good day. Thanks.